ಈ ಒಂದು ವೇದಿಕೆ ಸಜ್ಜಾಗಿದೆ. ನಮ್ಮ ಭಾಗ್ಯ ನಮ್ಮ ಮನೆಗೆ ಮತ್ತೊಮ್ಮೆ ಬಂದ ಅನುಭವವನ್ನು ನಾವೆಲ್ಲ ಪಡಿತಾ ಇದ್ದೇವೆ ಅಂತ ಹೇಳ್ಕೊಳ್ಳಲಿಕ್ಕೆ ಹೆಮ್ಮೆ ಪಡ್ತಾ ಇದ್ದೀನಿ. ಅದೇ ರೀತಿ ಕಾರ್ಯಕ್ರಮವನ್ನು ಉದ್ಘಾಟನೆಗೊಳಿಸುತ್ತಾ ಬೆಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಗಳಾದಂತಹ ಶ್ರೀ ಎಚ್ ವಿ ಪ್ರವೀಣ್ ಗೌಡ ಅವರು ಎಲ್ಲರನ್ನೂ ಸ್ವಾಗತಿಸಬೇಕಾಗಿ ಕೇಳ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ.
Good afternoon, all. Dignitaries on the dais, our lawyers. ಇವತ್ತಿನ ದಿವಸ ಫಸ್ಟ್ ಆ್ಯಂಡ್ ಫಾರ್ಮೋಸ್ಟ್ ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್, ದಿಸ್ ಇಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ನಾವು ಸದಾ ತಮ್ಮ ಮಿಸ್ ಮಾಡ್ಕೊತಾ ಇದೀವಿ ಅಂತಕ್ಕಂಥದ್ದು ಎಲ್ಲ ವಕೀಲರ ಭಾವನೆ. ಸೊ ಇಟ್ಸ್ ಲೈಕ್ ವಿ ಫೀಲ್ ದಟ್ your lordship coming back to us parental house. ಮೊದಲನೇದಾಗಿ ಇವತ್ತಿನ ದಿವಸ ನಮಗೆ ತಾವು ಸಬ್ಜೆಕ್ಟನ್ನು ತಾವು ನೋಡಿರ್ಬೋದು. ಸೊ ವಿ ಫೈಂಡ್ ಹಿಸ್ ಲಾರ್ಡ್ಶಿಪ್ ಇಸ್ ದ ರೈಟ್ ಪರ್ಸನ್, ಜಸ್ಟಿಸ್ who could address the gathering with respect to transparency in judiciary. As his program was scheduled at Bangalore, when we requested him, though he had too much of work schedule, still having given heard us, he has accepted our invitation, he has come here to address the advocate fraternity with respect to transparency in judiciary. And moreover, we wholeheartedly welcome you, sir, on behalf of the bar, as well as I welcome you on behalf of myself. And our beloved president is always there in organizing these kind of seminars, which is very much required to the young members of the bar as well as the members of the bar. So I welcome our beloved President Vivek Reddy on behalf of the Advocate Association as well as on my personal behalf. ಅದೇ ರೀತಿ ಈ ವೇದಿಕೆ ಮೇಲೆ ನಮ್ಮ Advocates Academy, one of the kind in entire country where it is the Justice Oka was saying, expressed about the academy was introduced in Bombay as well as Pune, and now it's our academy is one of the academy which keeps giving, educating upcoming judges, classes to judges, and it has been started by our former president D.R. Jagdish. So especially this academy was started for the advocates who have come from the rural background. We used to give them English teaching courses as well as about seminars about various subjects. ಈ ಅಕಾಡೆಮಿಲಿ ನಾವು ಜಡ್ಜಸ್ ಆಗ್ತಕ್ಕಂಥವ್ರಿಗೆ ನಾವು ಕ್ಲಾಸಸ್ಸು ಸಹ ಮಾಡ್ತಾ ಇದ್ವಿ. ಈ ಒಂದು ಅಕಾಡೆಮಿ ಸ್ಟಾರ್ಟ್ ಮಾಡಿರ್ತಕ್ಕಂಥ D.R. ಜಗದೀಶ್ ಅವರು ವೇದಿಕೆ ಮೇಲಿದ್ದಾರೆ. ಅವರು ಸಹ ನನ್ನ ಸಂಘದ ಪರವಾಗಿ ಸ್ವಾಗತವನ್ನು ಕೊಡ್ತೇನೆ. ಅದಕ್ಕೆ ನಮ್ಮ ಟ್ರಸ್ಟಿ ಆಗಿರ್ತಕ್ಕಂಥ ಪ್ರೊಫೆಸರ್ ಚಂದ್ರಶೇಖರ್ ಅವರಿದ್ದಾರೆ, ಅವರು ಸಹ ನಾನು ಈ ಸಂದರ್ಭದಲ್ಲಿ ಸಂಘದ ಪರವಾಗಿ ನಾನು ಸ್ವಾಗತವನ್ನು ಕೊಡ್ತೇನೆ. ಅದೇ ರೀತಿ ವೇದಿಕೆ ಮೇಲೆ ನಮ್ಮ ಅರವಿಂದ್ ಕಾಮತ್ ಅವರಿದ್ದಾರೆ, ಸದಾ ನಮ್ಮ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಅವರು ಬರ್ತಾರೆ, ನಮ್ಮ ಕರೆಗೆ ಹೋಗ್ಬಿಟ್ಟು ಅವರು ಸಹ ನಾನು ಈ ಸಂದರ್ಭದಲ್ಲಿ ಸ್ವಾಗತವನ್ನು ಕೊಡ್ತೇನೆ. ಅದೇ ರೀತಿ ವೇದಿಕೆ ಮೇಲೆ ಉಪಾಧ್ಯಕ್ಷರಾದ ಗಿರೀಶ್ ಅವರಿದ್ದಾರೆ, ನಮ್ಮ ಖಜಾಂಚಿಗಳಾದ ಶ್ವೇತಾ ರವಿಶಂಕರ್ ಅವರಿದ್ದಾರೆ, ಉಪಾಧ್ಯಕ್ಷರಾದ ಚಂದ್ರಶೇಖರ್ ಪಾಟೀಲ್ ಅವರಿದ್ದಾರೆ, ಹಾಗೂ ಹರಿಣಿ ಅವರಿದ್ದಾರೆ. ಅವರಿಗೆಲ್ಲ ನಾನು ಸ್ವಾಗತವನ್ನು ಕೊಡ್ತೇನೆ. ಇವತ್ತು ನನಗೆ ಮುಂದಿನ ನಾನು ಪ್ರತಿ ಸತಿ ಹೇಳ್ತೀನಿ, ನಮ್ಮ ಜಡ್ಜಸ್ಸು ಬಂದು ನಮ್ಮ ಅಸೋಸಿಯೇಷನ್ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗಿಯಾದರೆ ನಮಗೆ ಅದರಲ್ಲಿ ಆಗ್ತಕ್ಕಂಥ ಸಂತೋಷ ಯಾವುದರಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಈ ಸಂದರ್ಭ ಹೇಳ್ತಾ, ಕೆಲವು ಸತಿ ಜಡ್ಜಸ್ನ ಫೇವರ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ವೆಲ್ಕಮ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ತಮ್ಮ ನೋಡ್ತಾ ಅಂತಂದ್ರೆ ನಮ್ಮ ಮುಖದಲ್ಲಿ ಎಲ್ಲ ವಕೀಲರ ಮುಖದಲ್ಲಿ ನಗುವಂತ ಕಾಣಿಸ್ತದೆ. ಇವತ್ತು ಮೋಸ್ಟ್ ಆಫ್ ದ ಜಡ್ಜಸ್ ಆರ್ ಬಿಫೋರ್ ಅಸ್. ವಿ ವೆಲ್ಕಮ್ ಆಲ್ ದ ಜಡ್ಜಸ್ ಆಫ್ ಅವರ್ ಆನರಬಲ್ ಹೈಕೋರ್ಟ್ ಹೋರಾಟಲ್ಲಿ. ಅದೇ ರೀತಿ ಹಿರಿಯ ವಕೀಲರು ಎಲ್ಲ ಸಹ ಇದ್ದಾರೆ. ಅದರಲ್ಲೂ ಇಲ್ಲಿ ನಮ್ಮ ಜಸ್ಟಿಸ್ ಓಕ್ ಬಂದಾಗ ಕಾಫಿ ತಗೊಬೇಕಾದ್ರೆ ಕಾಫಿ ತಗೊಂತ ಟೇಬಲ್ ಸುಮಾರು ಜನ ಮಾತಾಡ್ಸಿದ್ರು. ಈ ರಿಮೆಂಬರ್ಸ್ ಮೋಸ್ಟ್ ಆಫ್ ದ ಸೀನಿಯರ್ ಡೆಸಿಗ್ನೇಟೆಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಆಫ್ ದಿಸ್ ಅವರ ಹೈಕೋರ್ಟ್. ಸೊ ಅದನ್ನ ನಾವು ನೋಡ್ಕೊಬೇಕು, ಅದನ್ನ ನಾವು ತಿಳ್ಕೊಬೇಕಾಗ್ತದೆ. ಈ ನಮ್ಮ ಅಸೋಸಿಯೇಷನ್ಲಿ ನಮ್ಮ ಒಂದು ಬಾರ್ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಪ್ರತಿಯೊಂದನ್ನು ಸಹ ಅವರು ನೆನಪಿಟ್ಕೊಂಡಿರ್ತಕ್ಕಂಥದ್ದು ನಾನು ಈ ಸಂದರ್ಭದಲ್ಲಿ ನಾನು ಪುನರುಚ್ಚರಿಸ್ತಾ ಎಲ್ಲ ಹಿರಿಯ ವಕೀಲರನ್ನು ನಾನು ಈ ಸಂದರ್ಭದಲ್ಲಿ ಪದಾಂಕಿತ ಹಿರಿಯ ವಕೀಲರನ್ನು ನಾನು ಸ್ವಾಗತವನ್ನು ಕೋರ್ತೇನೆ. ಅದೇ ರೀತಿ ನಮ್ಮ ಯಂಗ್ ಮೆಂಬರ್ಸ್ ಆಫ್ ದಿ ಬಾರ್ to whom this seminar, especially the subject transparency in judiciary, is ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್. ಸೊ ಎಲ್ಲ ನನ್ನ ಪ್ರೀತಿಯ ಕಿರಿಯ ಹಾಗೂ ಹಿರಿಯ ವಕೀಲನ ಸಂಘದ ಪರವಾಗಿ ನಾನು ಸ್ವಾಗತವನ್ನು ಕೊಡ್ತೇನೆ. ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ನಮ್ಮ ಎಲ್ಲ ಯೂನಿಟ್ನ ಪದಾಧಿಕಾರಿಗಳು ಆಗಮಿಸಿದ್ದಾರೆ, ಅವ್ರಿಗೂ ಎಲ್ಲ ಸಹ ನನ್ನ ಸಂಘದ ಪರವಾಗಿ ಸ್ವಾಗತವನ್ನು ಕೊಡ್ತೇನೆ. ಹಾಗೂ ಬಂದಿರತಕ್ಕಂಥ ಪ್ರಿಂಟ್ ಆ್ಯಂಡ್ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಮೀಡಿಯಾದವರು ಸಹ ಇದ್ದಾರೆ, ಅವ್ರಿಗೂ ಸಹ ನಾನು ಈ ಸಂದರ್ಭದಲ್ಲಿ ಸಂಘದ ಪರವಾಗಿ ನಾನು ವೈಯಕ್ತಿಕವಾಗಿ ಸ್ವಾಗತವನ್ನು ಕೊಡ್ತೇನೆ. ಈ ಸಂದರ್ಭದಲ್ಲಿ ನಮ್ಮ ಅಧ್ಯಕ್ಷನ ನಮ್ಮ ಜಸ್ಟಿಸ್ ಓಕ್ ಅವ್ರಿಗೆ ಒಂದು ಬುಕ್ಕನ್ನು ಕೊಡೋದ್ರ ಮುಖಾಂತರ ಸ್ವಾಗತ ಕೋರಬೇಕಾಗಿ ವಿನಂತಿಸ್ಕೊಳ್ತೇನೆ. ಮತ್ತೊಮ್ಮೆ ಎಲ್ಲರನ್ನು ಸ್ವಾಗತ ಕೋರ್ತಾ ನನ್ನ ಎರಡು ಸ್ವಾಗತ ಭಾಷಣವನ್ನು ಮುಗಿಸ್ತೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ.
ಎಲ್ಲರನ್ನು ಸ್ವಾಗತಿಸಿದಂತಹ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಯವರಿಗೂ ಕೂಡ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಸ್ವಾಗತಿಸುತ್ತಾ, ಇದೀಗ ಕಾರ್ಯಕ್ರಮವನ್ನು ಕುರಿತು ಬೆಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಅಧ್ಯಕ್ಷರಾದಂಥ ಶ್ರೀ ವಿವೇಕ್ ಸುಬ್ಬಾರೆಡ್ಡಿ ಅವರು ಒಂದೆರಡು ಮಾತನಾಡಬೇಕಾಗಿ ಕೇಳಬಹುದು.
Honorable Justice Shri Abhay Shreenivas Oka sir, Shri Arvind Kamath, Shri Praveen Gowda, Girish Kumar, Shweta Ravishankar madam, judges who have come for this occasion, members of the bar, senior advocates, former office bearers of the Advocates Association. I think all of those who have come here agree that we must talk less, we must allow Justice Abhay Shreenivas Oka to come. So being the host, I will try to make my speech as small as possible on the request of several senior advocates. Small means 2 minutes. Justice Oka is a great phenomenon and he will forever be remembered by our High Court. All of you agree. And if one is a great human being, even after he is a Chief Justice, the post goes. Even after he is a Supreme Court judge and the post goes, the great human being in him will not be forgotten. And that is what we are seeing. We love him because of his, not only because of his great knowledge and humbleness, but because of his greatest integrity, which he held during his post as judge. So when we chose today's topic, we were generally on the institution and we wanted to see and ask and debate as to how to make our institution greater, how to bring greater accountability, transparency, integrity. And this is one of the best institutions in the world, the judiciary. We have some of the greatest judges here and all judges are striving hard. At least for us, there is recompensation, but for them, they are working hard. And therefore, to make our institution greater, to make it one of the best institutions of the world, would be creating a bulwark, a fortress of justice for this nation. That is why we are here. The bar today wants to discuss this issue. I also would like to bring to your notice that Advocates Association Bangalore is trying to spearhead the movement for transparency in judiciary. We united all the presidents of Advocates Associations of High Courts of India and met the Chief Justice of India during Yashwant Verma's situation. And we are also pressing for a relook at the judges appointment case, because judges appointment case has created a beautiful manner of appointing judges without interference of the executive, which is no doubt correct. But the judges case must also relook into how to bring accountability in the sphere of appointment or after appointment of judges. We appoint the judges, but how to bring accountability. I am glad today that this is an open forum to share our thoughts I thank so many judges for having come here, and they are endeared to us, and the love of the bar is always with them. We thank you, sir, for having come here. I now request Justice Oka, also I request Justice Oka to spare 10 minutes before ending for one important issue, how younger members of the bar can become great advocates. I request him to give his opinion and thoughts on that. Thank you very much, sir. I thank D.L. Jagdish, sir, who is who has founded the Lawyers Academy and given a great institution so that we can continue to do these works. And Professor Chandrasekharaya, sir, who is here, who acts as a guide for this institution. Thank you very much.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಅಧ್ಯಕ್ಷರಿಗೆ. ಇದೀಗ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರನ್ನ D.L. ಜಗದೀಶ್ ಸರ್ ಅವರಿಗೆ ಪುಸ್ತಕದ ಒಂದು ಮೂಲಕ ಗೌರವ ಸಮರ್ಪಿಸಬೇಕು ಕೇಳ್ಬೋದು. ಅದೇ ರೀತಿ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಗಳಾದ ಪ್ರವೀಣ್ ಗೌಡ ಅವರನ್ನು ಪ್ರೊಫೆಸರ್ ಚಂದ್ರಶೇಖರ್ ಸಾಹೇಬರಿಗೂ ಕೂಡ ಪುಸ್ತಕದ ಮೂಲಕ ಗೌರವಿಸಬೇಕಾಗಿ ಕೇಳ್ಕೊತಾ ಇದ್ದೀನಿ.
Now for the main important reason why we are here, Justice Abhay Shreenivas Oka, we request you to please give us your lecture. Thank you, sir.
Sister Anu Shivaraman, sister and brother judges of the Karnataka High Court, Mr. Vivek Subba Reddy, President of the Advocates Association, Additional Solicitor General of India, other office bearers of the Lawyers Academy, senior members of the bar, and other members of the bar who are present here in large numbers. For me, it is always a pleasure to come back to Bangalore, because I always believe that perhaps these 2 years and 3 months time which I spent in Bangalore, perhaps that was one of the best periods in my life, which I also can't forget. And therefore it is always a pleasure to come to this beautiful red building. Today's subject is of course very delicate. It's a very difficult subject, and if I have to speak in detail, maybe it will require 2 hours. Today morning at Bombay airport, I met a young lawyer from Mumbai. He was traveling to Bangalore to attend some function. So he had seen the flyer of this function. So now lawyers can afford to take liberties with me. So he posed a question to me. He said, "Sir, is it correct that now lawyers must be expecting fireworks from you?" Looking to the topic. So my answer to him was, sitting in MC Mehta bench, I was author of an order which prohibited any use of firecrackers in Delhi NCR region. So I am not expected to use firecrackers, though of course that order was later on modified. See, when we talk about transparency in any institution, there must be transparency, because transparency brings about accountability. And as all of us know, accountability is one of the core values of democracy. Now, when we talk about transparency in judiciary, of course, the first topic which comes to everybody's mind is transparency in collegium system. But there are other important aspects of transparency. I will leave you those aspects first and then go to the collegium. Younger lawyers may not be aware what used to happen in 80s and 90s when I started practicing. I think first part of transparency is all orders passed by the courts, any court, must be available to common man. Until we began with this 21st century, even orders were not available. As young lawyer, I remember it was very hard to get certified copies, hard to get copies of unreported judgments. We had to go and sit in the registry, go through the files, and then the requirement was that if you need certified copy in which you are not concerned, you have to file an affidavit setting out why you want it, and our applications used to get rejected. So first part of transparency was brought about in the beginning of this century when we started uploading all orders. Then websites of various high courts and district courts emerged where we started displaying the case status. I think the best move forward was in the form of National Judicial Data Grid, where under one umbrella you can see the entire record. Of course, I mean after the Supreme Court E-Committee to make a lot of improvisations. In fact, if you look at the National Judicial Data Grid, one part is available to public. The second part is available to the registry, third part is to the judges. Actually, it gives so much of data. If registry wants to know whether a particular judicial officer has kept so many cases pending for framing of charge, if you give search, you will get the entire data of number of cases pending before that officer for framing of charge. What we need to do on National Judicial Data Grid is introduce for public benefit figures of number of judicial officers available in every state and latest figures of just to population ratio, which is the most contentious issue. In fact, in my judgments I have said that I am saying it on public platforms as a judge and even after my retirement, that in 2007 we should have just to population ratio of 50 and today we are struggling at 22 or 23. Some states is lower than even 22. So those figures, and they are fluid figures, so those figures must be also available on National Judicial Data Grid. Coming to the websites of district courts, I think in some states there is a lot of transparency in the sense the data of judges on leave is also published apart from orders, but there is no consistency in all states. In fact, that should be the feature of displaying the names of the judges who are on leave. The other part of the information, see, ultimately when we talk about information, right to get information is integral part of Article 19(1)(a) and also Article 21. Very interestingly, younger generation may not believe what happened in Bombay in 2006. You must have heard the names. Shailesh Gandhi was the Chief Information Commissioner. There were early days of Right to Information Act. So Bombay High Court used to publish figures of yearly disposal or monthly disposal of all judges taken together. So he applied under Right to Information Act. I want figures of individual disposal by the judges. The High Court Information Officer rejected it, Appellate Authority rejected it. Ultimately, the Chief Information Officer, with great difficulty, passed an order directing High Court to display and provide those figures. Things were so different. I am talking about 20 years back when Times of India carried headline when Bombay High Court was forced to disclose those figures and it gave all the details which judge has highest disposal. Now when we talk about transparency, the debate triggered in at that time. I remember what bar members said. One very distinguished member of the bar said that, sir, this may not be a healthy thing to have these figures on public domain. He gave an example in Bombay High Court, his original side. He said that some judge for 3 months of roster, he may be doing final hearing of the suits. So his disposal may be 10 and somebody is doing 227 writ petitions or appeal from orders. His disposal may be 1,000 cases in a month. So that can't be the yardstick. Because somebody has figures in his favor, some judge has figures in his favor, that can't be yardstick to say that he is the most efficient judge. So it triggered in debate. But what is important is, then all other high courts followed that and now we have many high courts display those figures of individual disposal. But things were so bad in 2006, 20 years back, when we talked about transparency. And there is a debate is required whether we should publish such figures, because it has pros and cons. The second most important aspect of transparency is listing of cases. I have said about this as a sitting judge of the Supreme Court. Now let us take High Courts on one hand and Supreme Court on the other hand. In High Courts, there is a fixed roster, say for 3 months. So if I as a lawyer today file a bail petition I know before which judge it will be listed. There is certainty, there is no human intervention. And many high courts used to follow that practice which I used to follow here. We used to call their drop benches. So if there is recusal by one bench, while signing the roster I used to sign a separate order, that automatically case will go to a particular bench. The reason was why this roster is there. Apart from the fact that every judge must get different kind of work, there has to be certainty, there has to be transparency. Litigant must know before which court his case will go, fresh case will go. And why this practice of even having drop benches? It rules out manual intervention. Even Chief Justice can't intervene unless there is a transfer application before him. So this brings about lot of transparency in listing. And look what happens in Supreme Court. I have myself said openly that Supreme Court's one difficulty is that it's a Chief Justice centric court. If you go to the website, you will find under the title Judges Roster. But look at that roster. It is not a roster. It records which subjects are assigned to which judges. For example, subjects of civil law, they are under heading 901 to 905. Practically all judges have that subject. Then transfer petitions. Practically every judge has transfer petitions. Then election law, their subjects are 1801 to 1806. 6 benches have that subject. Environment law, 5 benches have that subject. So look at that. That is not a roster. That is the category of cases assigned to each bench. Criminal law is assigned to about 10 benches. So if a criminal writ petition, criminal SLP is filed, litigant or lawyer does not know before which bench it will go. And there comes the manual intervention, maybe by Chief Justice of India, maybe by registry. So this is something which has direct connection with transparency, which I have said openly as a sitting judge of the Supreme Court also, that there has to be a fixed roster so that rules out manual intervention. That's very important. And that introduces kind of a discipline. Now there is second part of transparency when it comes to listing. Many of you must be remembering in dark days of COVID, there used to be criticism of Supreme Court, some high courts, that under the garb of very urgent cases, only selected cases used to get priority. I always believed personally when I became judge of the Bombay High Court that every fresh case has to be listed automatically. Though I could not convince my Chief Justices, as far as my court was concerned in Bombay High Court, my own auto listing was there. So there was never any mentioning before me for listing of fresh cases. Cases used to come automatically. In fact, those who remember when I became Chief Justice from day one, I introduced a practice that new case will come up, fresh file case after 7 days, even if objections were not rectified. So what I feel is, when a case is filed, whether it is urgent or not, whether objections are rectified or not, automatically the case has to be listed. That also brings about transparency. And in fact, some of you must be remembering, in September 20, in dark days of COVID, we started auto listing. I think bail used to come after 3 days and all other cases after 7 days. Fridays, right. We had consulted members of the bar, Mr. Ranganath was the president, and the system worked so well from September 20 to July 21, barring May of 21, our disposal was more than filing in pandemic. Importance is not about disposal. Disposal is a secondary thing. Importance is about transparency in listing. Every litigant must know when his fresh case will be listed. So, auto dating is perhaps the solution to bring about transparency in listing. About listing, there is one more very important aspect which I had to deal with in Bombay High Court, I had to deal with here. I was chairperson of the Case Management Committee of Bombay High Court. I used to interact with the lawyers, and I was a lawyer practicing in the High Court. We learn from our seniors. We used to find, as a lawyer also has to find, that the causeways used to be cut. So suppose 100 cases are due, judge used to say list only 60. I remember a brilliant speech by Justice R.M. Lodha, who became Chief Justice of India. He was the Supreme Court judge. Once he said that all judges must remember that cause list is of the court and not the judge. So suppose today as a judge I pass an order keeping a case on say 30th April. By that time roster changes, the successive judge is bound by that. He must list it on 30th April. So as a chairperson of the committee, case management committee, I persuaded the Chief Justice to follow a practice wherever judges used to cut the board, cut the cause list. Below the cause list, we used to list those cases which were excluded and we used to assign computerized dates to that. So I used to follow that practice. In fact, in Bombay High Court, my direction to registry was even if file is misplaced, the case has to be listed with the remark that file is misplaced. Some of you must be remembering, Supreme Court registry used to delete the cases. I passed judicial order that you have no business to cut my cause list. So in Karnataka also I faced this difficulty. No, judges used to pass orders, notice returnable after 4 weeks, but that case was never listed. Lawyers told me that you have to again move the court. So I passed a simple order on the administrative side. If judge says returnable after 4 weeks, calculate 4 weeks by looking at the calendar and case has to be listed 4 weeks after that date on which notice is issued. So what happens is, suppose 100 cases are due before my bench, and if I say that list only 70, issue of transparency arises here, then these 70 are chosen. Who chooses it? Whether some section officer or registrar chooses it or judge chooses it. Impossible for judge to choose it. So litigant will say, here is the issue of transparency. Why my case is deleted from the cause list? So I always believed, I say this in judicial academies also, when I conduct the training courses for High Court judges, that in a given day you may have 100, 200 cases listed before you, but don't cut the cause list. Because you have no right to do so. Some court has fixed a date, it must appear on that date. Otherwise, your system lacks transparency. As a judge, I am not bound to touch 300 cases. I may deal with 50 cases and give date to the other cases. That's also very important, to assign dates to the cases which have not reached. So that is the practice which I try to introduce. Now this is also essential part of transparency. Every litigant, every lawyer must know how cases are being listed. And to some extent that effort failed. When that criticism started, till August 20, I used to deal with all memos personally. So my registrar judicial had to remain awake till 3 o'clock in the morning because I used to go through those 300, 400 memos sent by email. The idea was not to create trouble but to have some uniformity. It should not be that one judge feels that this matter is urgent, other judge feels that this is not urgent, because we are listing only very urgent cases. So transparency has to be there in the listing. That's very important. And that is where litigant is directly concerned. Then comes a very debatable issue now. That debate started because of that NCRT article in 8th standard textbook about the complaints. Now people say, see, I go to all law schools now. I must have delivered at least 30 lectures in different law schools from June. So students are very inquisitive. They ask me question that why you are not publishing complaints against judicial officers and judges, and why you are not publishing the outcome of those complaints. Same thing is asked about the complaints against the High Court judges. I attended a legal workshop of consultants in medical field, all super specialists, when I was a sitting judge. So I was asked this question, that there are so many complaints against judges, but where is the transparency in your system? I answered, which I want to repeat today, because transparency is not a straitjacket formula. When we consider transparency, we have to consider privacy and we have to consider larger interests of the institution, namely that judges should be in position to discharge their duties without fear. Look at the nature of duties of the judge. I am sitting in High Court. If I dispose of every day 60-70 cases, I can't please everybody. So 70 parties, 70 litigants are aggrieved parties. Because I decide in favor of 70 against 7, I decide against 70 litigants. Now litigants are such that their minds get affected, they are affected because they suffer injustice. So if I decide 70 cases every day, potentially I create 4 or 5 complaints against me. Because this is how the duty of the judge is. So a litigant who is aggrieved is bound to file false complaints. Same is the case with our trial and district court judges. Unfortunately, some good judges face this. Some lawyer gets up and says, sir, if you don't give me adjournment, I'll file a complaint against you in High Court. Judges are openly threatened. So, I'll tell you something very interesting. In Bombay High Court, this is rampant. We judges used to get complaints against us. There was one lawyer who used to send one letter every month addressed to the President of India, Chief Justice of India, Prime Minister, and copy to me that please transfer this judge immediately from Bombay High Court and transfer him to some remote place. Of course, I was transferred, but I was transferred to most beautiful place in India, that is Bangalore. That also as a Chief Justice. But this kind of letters we receive. So, at least lawyers must understand this, that what credence has to be given to the complaints. There are serious complaints. I'll come to that. Another funny incident I'll tell you. I was hearing a PIL assigned by Chief Justice. So there was one partying person, he got up. He said, sir, I am handing over one document to you. Please read this document. It was copy of one of the news. You know, there are many newspapers which doesn't have circulation. They are published only to publish the government advertisements, tenders, etc. It was such newspaper published in Bombay. So there was a headline, President of India orders inquiry against Justice Oka of Bombay High Court. Unfortunately, very beautiful photograph of mine was printed in that news item. So I read that. What happened was, some litigant complained to the President of India. And some clerks, maybe some administrative officer sitting there, he forwarded that complaint to Justice Department, Secretary of Justice Department, and the remark was, for necessary action. So the litigant picked up that word and headline that President of India has ordered action or inquiry against Justice O. For me it was a fun, but not that every judge will treat it as a fun. See, when we deal with, now let us come to the complaints against our trial court and district court judges. They are the most vulnerable in our institution. I think judges can leave, I don't know if they detain anybody. Even lawyers who have cases, they can leave because this topic is not going to be over. I can go on. The President has permitted me, so there is no problem. So that our trial and district court judges are the most vulnerable judges. I have experienced it personally. I come back to incident in Bangalore. Unfortunately, I had very bad attack of hepatitis. I was told to sleep for 21 days, but I decided to ignore that advice, and 8th or 9th day I came to the court. I came to the court, Registrar General handed over a very leading newspaper in Karnataka, which had headline, under the instructions of the Chief Justice, Vigilance Branch of the High Court raided house of a city civil court judge in Bangalore, and cash of 9 crores was found. Lot of spice was added to that. There is one local television channel. It showed clip of a counting machine counting notes. One more interesting part was there. That Chief Justice has ensured that about 30-40 judicial officers are sent home by way of compulsory retirement. Of course, that was element of truth in that. That was their news item was correct. But latter part was that Chief Justice summoned about 40 district judges to his office and told them to resign, otherwise action will follow. Completely blatant, because Vigilance Branch has no authority to raid house of a judge. I met families of city civil court judges in those days. They said, sir, to our family members, people are pointing fingers because we happen to be family members of the judges of the city civil court. Look at the drastic effect of such news item, such false complaint on the family members of the judges. Please remember one thing. Nowadays, complaints against judges are forwarded to their residents also. Their school going and college going children read those complaints. Of course, then newspaper came, they apologized. They came out with the code of conduct. I asked that channel, how could you show that? They said, no, we have those clips ready, Somebody counting notes on the counting machine. I am giving example from Karnataka. What I feel is, as far as trial and district court judges are concerned, there has to be a machinery to deal with the complaints. The process which is adopted by the machinery has to be transparent. See, please remember one thing. By publishing, you don't achieve transparency. Transparency has to be there in the process. Maybe that process has to be known to everybody. And there is a process. I have been part of Administrative Committee of Bombay High Court, Chief Justice here. There is a process that every complaint against every judicial officer is processed. 90% of complaints are found to be false, so no further action is taken. But there are cases where remarks are called for, disciplinary action is taken, that action is taken. So there has to be, absolutely true, that there has to be a method for dealing with each and every complaint in a transparent and fair manner. No doubt about it. But you can't say that, publish that complaint. Because you can't ignore the role played by the judges. Now it comes to High Court judges. Kind of orders which we pass sitting in the court. We offend so many people. In Bombay High Court, I used to receive complaints against me, at least 8 to 10 complaints every day, every week practically. Some of you must be remembering. Mr. Nargund is here, they are all at receiving end. Mr. Vikram is here. We used to take this COVID litigation for 3-4 days in a week. So every day, I have received personal letters at my house complaining about my own orders. That what business you have to direct that particular quota of oxygen should be released to Karnataka. So complaints will be there against the High Court judge, but look at the manner in which they discharge their duties. Why there is a scenario today which people openly say that in a deserving cases our sessions court don't grant bail. The reason is this menace of complaints. So while I reiterate, for the sake of transparency, there has to be a very fair and transparent process of dealing with every complaint. It must be there. But if you say that those complaints should be published, orders passed should be published, we will be compromising on not only integrity of the judges, we will be compromising on quality of fearlessness of the judges. So we have to strike a right balance when it comes to transparency. And complaint, I'll refer to that NCRT article. What does the article say? Between 17 to 21, there are 1800 complaints or 1600 complaints. In those days, I think their total number of High Court judges were about 600. So let us take minimum that every judge disposed of even 500 cases per year. It must be much more than that. So 600 cases, judges must have disposed of 3 lakh cases every year. And how many are the number of complaints? 1600 complaints. So what I have said is that number of complaints is not the measure of corruption in judiciary. Those complaints can be motivated, they are motivated. In fact, as part of administration, Bombay High Court and here, whenever I used to find record of a trial court judge where there are no complaints against him. So one of the obvious conclusion was that he must be deciding routine cases. He may not be passing any bold orders. He must be playing safe. And therefore there are no complaints. So number of complaints filed against the judges is not a measure or not a standard to measure corruption in judiciary. Corruption is there, nobody can dispute it. And that's what my reaction to that NCRT controversy. Of course, I have also said on public platform that the action which was taken by Supreme Court may not be correct. That also I have said. So therefore, when we talk about complaints and we talk about collegium system and we talk about transparency, now let us talk about collegium system. There are critics of collegium system, no doubt about it. Somebody can say with justification that collegium has not performed the way the larger bench expected collegium to perform. Yes, criticism must be there, is there. But we cannot get rid of collegium system unless there is a better system which rules out government interference. Always an existing system can be always replaced by a better system. Now about collegium, fortunately when Chief Justice was Justice Sanjeev Khanna, entire collegium process is on website. I'll describe in short. The proposal initiates from the High Court, it goes to the Governor and Chief Minister of the state. They have right to offer their comments about every candidate. Then it goes to the central government, there is IB inquiry. And what kind of IB inquiry is there? Even the format of IB inquiry report is on the website. And after IB inquiry and after receiving the remarks of the stakeholders like Governor and Chief Minister, normally it is Chief Minister. Then Law Ministry prepares its own comments. Who prepares? On that there is no transparency. And along with the IB report, the views of the state government entities like Chief Minister and the views of the central government, they come before the collegium. And what is the extent of IB? Please go through that material on the website. A very thorough IB inquiry. Maybe just like any investigative agency, there may be element of prejudice in those inquiries also. I am not saying that, but what is important is very thorough IB inquiry, and at every stage the stakeholder, namely government, has a say. And you know the judgment that if Supreme Court Collegium recommends a candidate, once the name can be sent back for reconsideration, after it is reconsidered and reiterated, the government has to sign on dotted line. So as a part of transparency, the entire process of collegium is on website. You can read that. Even formats are given, formats of recommendation, everything is there on the website. There is second part of it, which I will come to later, that where we are groping in the dark. I will come to that part little later. Now, practice of publishing, this collegium resolution started. I firmly believe that by publishing collegium resolutions, you can't bring about transparency. Transparency has to be in the process of mechanism of collegium. Whether the collegium considers all eligible candidates who are in the zone of consideration, and manner in which it is considered, manner in which feedback is taken from the stakeholders. It's not uncommon that Chief Justice of the High Court calling Advocate General or President of the Bar to get views about certain candidates. In fact, for your benefit, I want to tell you, in August first week of 2021, Collegium consisted of myself, Justice Satish Sharma and Justice Nagaratna. We have passed a detailed resolution laying down all parameters for considering cases of elevation of our district judges. What should be the zone of consideration? How their judgments will be assessed? What should be the cut-off marks? Everything we have written down in writing. So, I believe zone of consideration should be 1:3, and how it should be considered, that's in black and white. So idea was to reduce the discretion available with the collegium members. I don't know whether it is being followed or not, but it's very much there. Look at some of the collegium resolutions. Now let us understand all our lawyers. I don't know how many of you read latest speech by Justice Deepankar Datto in Bangalore, where he candidly and correctly said that some good lawyers are not willing to come forward and say yes to when they are offered High Court judgeship. I had a rider here, but don't be under impression that those who have said yes are not good. They are also good. And he said something very interesting. I know that case. He said he heard from his predecessors that when eminent lawyer was called to give consent, he said, "Sir, I have 4 or 5 pet dogs. Salary won't be enough to feed those dogs," and therefore he refused. 4 lakhs. Right. Now this is the scenario. Now you are publishing collegium resolutions. So and so is recommended to be appointed as judge of Karnataka High Court or any High Court. What happens thereafter is shocking. Sometimes it takes 9 months, 10 months, year. People wait. And understand psychology of a litigant. If he reads the name of a lawyer practicing in High Court and his name is recommended, who will give cases to him? And please understand this. They are all in the age group of 45 to 50. When their children are grown up, they have to pay fees of the college, there are coaching classes, maybe somebody has installment of bank to pay. And this is where the problem is, because we don't know why government takes so much of long time, 9 months, 10 months. Who takes the decision? So this is one reason why lawyers say that, I experienced that. I was a member of the collegium. We used to call some candidates with the consent of the Chief Justice. They would say, "Sir, I am willing. I don't want to face this uncertainty." There are instances where after collegium resolution was published, because it took 9 years or 11 months, 1 year, lawyers were without work. What happens to the family members of the lawyers? One more instance I'll give. Read those collegium resolutions. I am not saying that. One collegium resolution of one particular High Court was published in entirety. Now, collegium resolution refers to average income of the lawyers. Is it not encroachment on the privacy? I received a letter as a consulting judge in the Supreme Court. The letter was that, look, in this resolution, income of one particular lawyer is mentioned at X amount, and he must be evading income tax. What was the necessity of publishing it? There was one case where a consulting judge recused because the lawyer had worked with him. That is not mentioned in the collegium resolution. What is mentioned in the collegium resolution is that this candidate happens to be junior of a sitting judge of the Supreme Court. It is not mentioned that that sitting judge recused himself as a consulting judge. So what is will publication of these full resolutions bring about transparency? As my judgments can be wrong, I may be wrong in my opinion, but I feel that transparency has to be in the process of the collegium, where all stakeholders must be consulted, all those who are eligible must be consulted before recommendations are made. Additional Solicitor General is here. Please place yourself in the position of those candidates whose names are published on the website and 10 months they are without work. And this is the difficult part of it. I am very glad that Bangalore Bar Association filed a contempt petition, because law is very clear that proposals have to be cleared within reasonable time. If there is reiteration, government has to sign on dotted line. Look at one case from Karnataka. Long time it took for government to decide to send back the file. There are reiteration, and in the process, I am saying it openly, in the process we lost a good judge, system lost a good judge. So we don't know why this delay is there. I'll give one more example, classic example. In case of some high courts, you see the pattern. Some judges are directly appointed as permanent judges. We don't know why. Because every recommendation made by the High Court Collegium says that we are recommending a candidate for being appointed as judge of the High Court, not as additional judge of the High Court. One case from Bombay, my own High Court. The time gap between date of collegium recommendation of Bombay High Court and actual warrants was 3.5 months, unheard of during the last 20 years. Welcome, but do it in every case. And this is the first time when more than 7 or 8 candidates are recommended, all candidates are approved within span of 3.5 months. It happens in every case, most welcome. I will be the first person to welcome it. But it happens in selected cases. So if we want transparency, transparency must be also there about the decision making by the government. Because what government wants to say is before the Supreme Court Collegium. That format is also there on the website, please see that. So we don't know where the file goes, who is the decision making authority. After the name is reiterated by Supreme Court Collegium, who is the decision making authority who decides to keep the file pending. I was part of the bench dealing with Bangalore Bar Association contempt petition. Unfortunately, they were listed thereafter. Very bold move by Bangalore Bar Association, I will say. Ultimately, what was the interest? Interest was that Constitution bench judgments should be implemented. Then, so what purpose you are going to serve if you are going to declare what is the lawyer's income? I believe in transparency, therefore I was party to decision making where we declared our assets on the website of the Supreme Court. Nothing wrong with that. If every public officer does that, why not judges? We have to do it. In fact, we used to do that. We used to hand over our asset statement to the Chief Justice. Whenever there was change in the asset position, we used to hand over fresh statement. But now Supreme Court is concerned, it is on website. Some of the judges may not have published it, but it is there on the website. Now the other issue is about transfers. I must tell you one thing. When lawyers are called upon to give consent, we have to give undertaking that we are willing to go in any high court. In fact, you have to give preference to, in preferential order, names of the 3 high courts. Interestingly, I had given preference to Karnataka and Gujarat, they are neighboring states. But it took 15 years and 9 months for me to reach here. That's a different thing. So, every candidate who gives consent, his consent is taken to go to any high court. In fact, in 1994, you know the system. Senior members may be aware that 1/3 judges in all high courts were judges from the other high courts, other states. Now, please consider one thing. Somebody told me that why collegium's reasons should not be published for transfer. Please place yourself in position of those judges. If those reasons are published, they have to go to other high court and function there. Will it bring about transparency in the system? Sometimes inadvertently we say something which is glaring. Classic cases of one judge from Madhya Pradesh who was brought back by the Collegium to Madhya Pradesh. Collegium recommended a transfer to A state. Before that transfer could be effective, fortunately Collegium said it very candidly. At the request of the government, we are transferring him to B state. That is there in the Collegium resolution. So it's a matter of debate whether Collegium should assign reasons, and those reasons should be published when judge is transferred. Then so many questions will be asked that when a judge is transferred about 1.5 years back, why suddenly he is elevated to Supreme Court? When judge is transferred from one high court to other, why he is made Chief Justice of one of the oldest high courts? Those questions will be asked. So therefore, what I am trying to canvass before you is that we must understand what is transparency and what brings about transparency and accountability. Because when we consider transparency in judiciary, accountability has to be there, procedures have to be transparent, no doubt about it. But that transparency has to be balanced with the first and foremost need of judges discharging their duties without fear, and secondly, privacy. Take a case where Collegium says these are the reasons why this advocate is of doubtful integrity, therefore we are not recommending his name. That man has to practice in the court. He takes a risk by giving consent and then he suffers perpetuity. It happens, some of the names are rejected, then members of bar start asking questions why his name is rejected by the Collegium. But so therefore we have to balance each factor, and fearlessness of the judges cannot be casualty in this process. Again I say, what I say is debatable, but surely it calls for debate. While I say and I justify that transparency has to be there. I know that I can go on and on, but you have to appear in court. But few things I have to say about the younger members of the bar. Last about 10 to 12 years, whenever I found time, I was going to law colleges and law schools, having interaction with the law students. Now, as I said, practically 2 lectures per week I deliver in some law school, because that is my passion. One very important aspect which I want to tell for the benefit of young members of the bar. You may be, I must say one thing, that present batch of students or fresh law graduates, if I compare them with me as a fresh law graduate in 1983, they are much more equipped in terms of knowledge of law. Because the legal education has improved considerably with 5 years course, with full-time course, residential courses, legal education improved. But with that, what I find is younger members of the bar want instant success in the profession. I always tell them one thing: you may be having great knowledge of law. The precedent must be maybe on your fingertips or in your memory. But you have to first remember that you are officer of the court. You are officer of the court first. And therefore, you must learn what is known as art of advocacy. And art of advocacy you can learn only by sitting in court and not by standing in corridors and chit-chatting. And I belong to that generation where our conduct as junior lawyers was watched by seniors and we were given warning. Now today some seniors told me that if they try to tell something to a junior lawyer, that look, you are wrong. I'll tell you a very simple case. I joined the bar. Immediately after I joined the bar, within 1 year my senior was elevated. I decided to continue on my own. But in those days there were senior lawyers who used to give some work. So I was sitting in the court. I was told by my senior, sit in the court from Bombay it was 11 to 2 and quarter to 3, quarter to 5. Don't be in corridor. So it was great education. I have seen great lawyers in action in those days. I have seen Ram Jethmalani arguing criminal appeals, though very little I could understand of criminal law. So one lawyer came to me, he said, sir, Arey, you are sitting here. So there is a matter at serial number so and so. So when it reaches, mention for adjournment. Because I have to leave, I have to go home, there is some emergency. What I did was, I mentioned the matter at 2 o'clock before when judge was rising. Judge promptly rejected my request. He said, you mentioned when matter reaches. There was one senior lawyer sitting there. He said, young man, come with me. Let us have a cup of coffee. He said, this is a simple thing you must understand. This first lesson in the art of advocacy. Judge sits there for 3 hours continuously. Sometimes he hears all nonsense also. His patience is tested. So mentioning at 2 o'clock when judge is about to rise is the most awkward time to mention. Natural human conduct. And I realize more in hurry to go to your chamber. Simple lessons were given to me. I was arguing a case. One defendant came to me. I was 2 years I practiced in trial court. Money suit, simple money suit based on negotiable instruments. Obviously, I realized litigant came to me because he had a hopeless case. So it was a great opportunity for me to cross-examine. So I asked one question. Judge said no. I am disallowing the question, irrelevant question. Then I wrote down an application, sir, I want ruling on this. So this went on for half an hour where my 10 questions were disallowed. I felt that I am right. I am asking correct question. What is the business of this judge of saying no to it? Again, one senior gentleman came to my rescue. He said, young man, have you realized what damage you have done to your client's case? Now, I agree that these were crucial questions. Judge should have allowed it. But now he have to challenge these orders in the High Court, and it costs when you go to High Court against interim order. Because unless those questions are asked, perhaps you cannot bring your case. You have to put your case. So he told me very simple advice, which I am sharing for the benefit of young members of the bar. He said, if judge disallows question, go before the judge, say, your honor is absolutely right, your lordship is absolutely right. I'll go to next question. Ask few irrelevant questions. After 10-15 questions, ask the original question in a different language. Judge will allow it. Judges are also human beings. So therefore, these are the basics of art of advocacy. Some young lawyers, very competent in Supreme Court also, Karnataka High Court also, I had told 2 young lawyers that please remember that this is not a moot court. So when you argue before High Court in admission matter, don't go with preconceived ideas like moot court. You can't say that you will decide which is the first point you will argue. If say you are arguing a second appeal for admission, first point is of limitation, second point of res judicata, you are very confident that appeal must be admitted on the point of bar of limitation point, and then again his statement cannot be believed for face value. So I tell this to judges that we must study the lawyers. Similarly, it is important for young lawyers to study the judges. What arguments the judges like, what kind of discipline the particular judge wants. Because ultimately, why you are there as a lawyer? You are there as a lawyer, your first and foremost duty is to ensure that the judge arrives at a correct legal and factual decision. That's your duty. And therefore, and second duty is, within your 4 corners of your ability, try to persuade the judge that your client has best possible case. While doing so, suppose there is a judgment of the Supreme Court against you. It is your duty to point out to the judge that, sir, there is a judgment of the Supreme Court against me, and you will feel that it is against me, but I want to distinguish on facts. If you do that, judge becomes more receptive. He feels that here is a young man who is so fair, he is pointing out judgments against himself. And then judge says, all right, I must give you opportunity to distinguish that judgment on facts. So, studying the judge is important, and most important is, there are so many good lawyers in this bar. And please remember one thing, never become part of shouting brigade. In the short run, it may help you that you shout at the judge. When your counterpart is arguing, you get up and start arguing. Maybe short-term benefits may be there, but long-term benefits are not there. On the contrary, you will be branded as a cantankerous lawyer by some of the judges. So therefore, remember that ultimately you are so important part of our system that you have to help the judge in arriving at the correct legal position and factual position. So, see, I did not have much work to do in the beginning. A brilliant argument by Ram Jetmani. I had no work. There was a division bench, 302 appeal. And very rarely that defense was of intoxication. The accused was intoxicated. So Mr. Jetmalani, within the span of 1.5 hours, told the court what is the relevance of the defense, how this defense emerged. He referred to various material on the record. What exactly goes wrong with the human psychology, that he doesn't have control over his senses and is intoxicated. So this is what you learn, and this you will never learn once you start getting your practice. There is no time to sit and hear these great people. So this is the piece of advice for me, that truly become officers of the court. And I will repeat what Justice M.C. Chagla had said. Justice M.C. Chagla has said in his book that every junior lawyer has to show patience, which he says that he was a defense lawyer for 5 years. And this is such a beautiful profession that if you succeed in the legal profession, nothing succeeds like a success. You talk to your chartered accountant friends, all of them say that legal profession is the most lucrative profession in India. Maybe it may be wrong impression. So you have to show a lot of patience. And you have to wait for the opportunity, and when you get opportunity, grab it with both hands. That's what I wanted to convey to the junior members of bar. Mr. Vivek Reddy requested me to do so. I know that I can go on and on, but all of you have to work, and so somewhere I have to stop, and I must stop here. I'm really glad that so many of you attended this lecture, and I went down in the memory lane. When I met lawyers, I had coffee with them. It was a great pleasure for me. Thank you.
Sir.
Just 2 or 3 questions, which I will ask Abhay Shreenivas.
Judiciary. One of the finest judge of the we witnessed is the judge, Chief Justice of this court and a judge of the Supreme Court. I have a question. In so many places, in a seminar and a lecture, Justice Oka has said people are losing the faith in the judicial system. What exactly the factors of your experience goes? What are the factors, what are the reasons? Now the present we are in a crossroad. People nowadays, everybody speaks, people are losing the faith in the judicial system. I wanted to know from the Honorable Justice Oka.
No doubt that I have said on so many platforms, even as a sitting judge I have said that. See, the reason is you can perceive that you are sitting in the court. There is an issue of delay. An issue of delay arises mainly, I have said so in one of the constitutional judgments also, that when we should have a ratio of 50 per million in 2007, we were studying at 20, I said so in Allahabad High Court full bench constitutional judgment. And it's a fact that common man feels that the judiciary has not fulfilled expectations which members of the constitution had from them. And there are a combination of reasons why this happens. And one very important reason is they are simply flooded with cases and cases. And then sometimes some good lawyers are willing to give consent. They are deprived of their services also. And that has implications. Other lawyers also say, no, I don't want to become a lawyer of the High Court. So there are reasons and what he said is right. I have said that. And why I said that, when I say it is before stakeholders. The idea is to see that we improve. When I speak to judicial officers, I say, so the idea is that I want to inspire judicial officers to perform better in the 4 corners of limitations. And when I say this because the lawyers and judges, idea is that everybody comes together and try to improve the system. That's the only idea. And I don't think anyone can deny this.
Question will go to answers. Any answer? Yes.
Sir, would the current political system adequately safeguard against nepotism? This is my question.
I will say this, you are just right. I have said that everybody has right to criticize judiciary, that there is nepotism. But I personally think that if at all there is nepotism, all this is where one instance of Karnataka, where a competent lawyer denied appointment as High Court judge. How many lawyers protested about it? Bangalore Bar Association filed a petition. It's still pending. I commended that. But whether these other members of the bar get to media and protested about it. I'm not putting blame on the lawyers. I always blame myself as a judge. Because I am part of the system. And there are instances, for example, in Bombay High Court, when the instances happen. There are 150 years oldest bar associations are in Bombay. Western India Advocates Association, the oldest association in India. They passed a resolution, unanimous resolution expressing doubt about integrity of 4 judges. Because bar members are very active. There are allegations made against a judge by state government of bias, and the Chief Justice transferred important case on that judge. Within 36 hours, Bombay Bar Association passed a very strong resolution containing Chief Minister, Chief Justice and Advocate General. Now, such role on the part of bar is expected. And of course, there are judges like Chittosa Shumari, Chief Justice, who do work for 4 judges. It's on both sides. Maybe that, I think, the profession has become more commercial now. Therefore, some people are reluctant to take stand. And I'm not saying that you fight. I'm not saying that you make cantankerous allegations, but at least in few cases where it is needed, stand has to be taken.
The confidence on because few judges are involved in corruption already. Then president of raised that issue in our meeting last time.
I'll answer the first question. Second question is very debatable. I don't know whether I should answer it. About bench of the Supreme Court. You know, I have been saying this in my judgments also, that most important courts in our system are our trial, district and sessions courts. They are the most important courts, courts of common man. Those who have infrastructure available to trial courts in Karnataka, which is far better than many other states, including my home state. But who in India find out what is the infrastructure available? In UP, most of the jails are sanctioned because there is no infrastructure, therefore jails are not being appointed to our trial courts. So when there is a need to spend a lot of money and provide a lot of infrastructure to our common man's court, imagine what kind of expenditure will be involved if you want to have a bench here of the Supreme Court. See, we are not a rich country, and therefore when it comes to priorities, we have to decide our priorities correctly. Whether today priority should be to appoint more judges and increase the judge to population ratio trial courts to 50. Because then if you increase the ratio, you have to provide corresponding infrastructure, court buildings, chambers. So priority should be to increase the strength of our trial court judges, because that is where common man is supposed to get justice. So ideally, justice at those steps is the consent, no doubt about it, but we don't need an ideal world. And therefore we have to set our priorities. I don't think that stage has come where we have robust machinery of trial courts, and therefore we can afford to have the luxury of multiple Supreme Court benches. And why not that luxury? You can file, make e-filing of cases appear online.
Nayak, ಹೇಳಿ ಸರ್ ನೀವೇ one second. Nayak.
So there are many female candidates who are advocates for practicing here. You can see there are so many ladies and efficient ladies are there. At most, whenever the collegiate determination comes, ladies have been given last preference. So what is your about this?
You are entitled to have an opinion that number of images appointed in high courts may be on the lower side, but look at the positive side also. During the last 5 years, all appointments as civil judges and judicial magistrates go to any state, go to even Bihar, 55 to 60%. Majority of time. See, nobody imagined 5 or 10 years back that there will be women judges, so because things have started changing. It's a nice question. Yes. Okay.
So what's your opinion on the former judges report imposing in favor of
only thing I tell you, every day is a mobile. I used to carry mobile phone. One day I carried it very bad, so I called authority. I said, take mobile to custody. I have to pay fine. So the question is, see, what I personally feel, it may be again wrong. Sitting in India, I have also criticized Indian judiciary. Sitting in India. But when we are abroad, my personal view is that our judges have to show restraint. On the contrary, international conferences, I proudly say that as far as criminal justice system is concerned, we are very proudly saying that we granted fair trial to even Ajmal Kasar. High Court was going to be adopted. High Court, one of the very seasoned lawyers, Supreme Court also got good representation. So, when we criticize our system, when we are sitting amongst the stakeholders in India, we must criticize. No doubt, because unless we criticize, there is no scope for improvement. But to depose in foreign country, and what I feel is, it's not, when you are studying the legal system in foreign countries, there are many, I am not naming those countries, there are many countries about which we talk about development, etc. But there are other courts, I am not naming those countries. So, my personal view is that we have to be very discreet and show restraint. See, as a judge, as a part of the system here, I am bound to criticize because I want people to improve, I want myself to improve.
Sir, my president has asked a bit that we need 3 questions. So, this is permission, another 3 more questions can be asked. 3 more questions. My lords here, as a...
Well, like I was saying, somebody should not say, because my presence here after 2:30 functioning on the Karnataka High Court and the advisory.
No, as you can see, it's almost full here, so we all want to hear it. As early as 2018, the live streaming was held as Article 21 of my right to life. But during our High Court, where courts are slow, no other courts are being live streamed. They may be plus and minuses, but my lords, we would like to hear from you.
Actually,
transparency starts from
when we started this video conferencing court, what we thought was that it should be like open court. So we used to publish the password in the morning on the courses. So the idea was, see, it was never our thinking that we want to have a stream. Our idea was that every lawyer, those cases, even the 50 must see court in action from 10:30. That was the idea, it should have open court. Now, live streaming, see, my personal view is that there should be live streaming. But in the flip side of it, people record it and out of context some clips are produced and are circulated on social media. That can cause some harm. So, if members of the bar, they become more responsible, I think live streaming is a good idea. I mean, why not? Because what we say in open court, we express our opinion, our opinion, that the idea is to bring best out of the lawyer. Right? So that lawyer knows what is passing in the mind of the court. But then, we need to have that kind of discipline. That you can't, you see the live streaming record only for 2 seconds, or 20 seconds or 30 seconds and circulate that. That may cause misunderstanding. But still, I personally believe, I am all for live streaming. Personally, but I think again there will be a debate on this. I want to just brief. I attended a lawyer's conference, I not name the state. So some lawyer complained to answer questions from by the judges. We had judges who spoke too much of the legislature and then they had to shut it off.
My lords, with the permission of our president, this is a bi-language monthly magazine, Vakil Wadani, of March 26. Yes, my lords. So it may be elaborated with the March 26.
Okay.
March 26. Yes, sir.
request from Senior Advocate Ravindranath Kamath that he wants to present the book, please. Yes.
Dignitaries on the dais and off the dais. It's my privilege and honor to propose a vote of thanks on this prestigious occasion. Today's enlightening address has truly enriched the knowledge and perspectives of our esteemed members of the bar. I thank Honorable Justice Shri Abhay Shreenivas Oka, former Judge, Supreme Court of India, for this wonderful address. Give him a big round of applause. I thank, in his absence here, the guest, Shri K. Shashikiran Shetty, Advocate General, Government of Karnataka, and Shri K. Arvind Kamath, Additional Solicitor General of India, for their presence. I also thank our wonderful leaders, the President Shri Vivek Subbareddy, the General Secretary H.V. Praveen Gowda, and the Vice President Girish Kumar for their presence. I also thank the executive members, the Vice President of High Court